Review petition by review petition.
Daily list or orders, item number 1.
Yes. Mention the review mention. Continuous lordship. I'd like to mention item number 5 we passed over for the day, my lord.
Item number 5, which one?
Review, my lord. Jamila
The
Khatam.
prayer of Mr. Sunsar. Yes, next.
Deeply obliged. Next, please, your lord.
Item number 1 for orders.
Lordship, I am praying for the review of the order dated 3/12/2018 filed by this honorable court, your lord.
Page number.
Page number 56, your lordship. It starts from 55. 56 is the relevant portions, your lordship.
Page 56.
56, 57, 56, 57, 58. Your lordship, in this matter, your lordship got it.
Yes.
Your lordship, in this matter, your lordship, I am declared foreigner mainly because of the reason that my father's name appeared in a voter list of 1966. His name is Sahid Ali. And it has been held by the honorable court, your lordship, that my name along with my elder brother's name appeared in the voter list of 1989. Your lordship will find on page 57.
Yes.
The exhibit B, the electoral roll of 1989, recording the name of the petitioner aged 29 years ago, which is two brothers, that is Atarjan Akan, aged 57 years, and Muslim Ali, aged 31 years, showing their relationship with one Sahid Ali, and single voter digitally certified copy of the electoral roll of 1993. Now, your lordship, it has been held that since my elder brother's age was 57 in the year 1989, so his age somewhere in the in 1966 would be 34 years. So it will be, my elder brother will be elderly than my father. Since my father's age is around 26 in the year 1966, and going by the voter list of 1989, your lordship.
Just a minute. Yes, yes.
Yes, your lordship. So it has been held since my elder brother Atarjan Akan, your lordship, it has been discussed in the second pair of page 57, your lordship. Save and accept the three documents above. No other voter list are produced and exhibited recording the name of the petitioner together with his projected father as voters. The whereabouts of the projected fathers after 1968 is also not explained in the written statement so far. What surprised the most is the Exhibit B, electoral roll of 1989. Looking at the age of his elder brother, Atarjan Akan, shown as 57 years, by simple arithmetic said Atarjan Akan was 34 years in the year 1966, when the age of his father Sahed Ali in the electoral roll of 1966 was recorded as 25 years. Clearly, Sahed Ali of the electoral roll of 1989 is a different person entirety from the Sahed Ali of electoral roll of 1966. In so far as Exhibit C is concerned, the same being a digitally issued document was not proved in accordance with law, thus making the said document as inadmissible in evidence. Now I'm coming to the first part, your lordship, the voter list of 1989. Here it has been calculated that my elder brother's age ought to have been 34 in the year 1966, when my father's age was around 25 or 26. Now, my humble submission before this honorable court is, your lordship, if your lordship peruse that document of voter list of 1989, I have annexed the read petition, your lordship, page 2930. 29 is the typed copy, your lordship, translated typed copy, and 30 is the vernacular one, your lordship. Your lordship will find.
And about 66?
66, your lordship will find on page 27, 28. 27 is the translated typed copy. Here the age of Sahed Ali has been shown as 25 years. 66. And in a voter list of 1989, Kitabjan Akan has been shown, the age of Atarjan Akan has been shown as 57. Now this our honorable High Court
Atarjan
Akan age has been shown as 57.
Who is Atarjan?
Your lordship, it has been held by this honorable court that he is my elder brother. But here, if in the gender column your lordship sees, your lordship will peruse that she at least she is a female, she is not my elder brother. Actually, Atarjan Akan is my mother, not my elder brother, your lordship. This is the error apparent on the face of the record, your lordship. My mother has been shown as my elder brother by the tribunal as well as this honorable court, your lordship. That's why, your lordship, the age difference, it seems like my elder brother is elderly to my father, which is not, your lordship. If your lordship, in the foreigner's case, we see, your lordship, there are some deviation of the age, your lordship, 3, 4, 5 years here and there. So if the age of my father was around 30 in 1966, and going by that, my mother's age also is around 30. If 4
Who is
plus
your mother? Who is your mother?
Atarjan Akan.
Atarjan Akan is your mother.
Yes, your lordship. She is my mother.
Who is Maher Ali?
Your lordship, it has been wrongly typed. This petition was not filed by me. It is Sahed Ali, your lordship, not Maher Ali. If your lordship goes to the vernacular, the next page, your
Who is
lordship, it is Sahed Ali. Sahed Ali is my father and the husband of Atarjan Akan. So the fact that Atarjan Akan has been projected as my elder brother, your lordship, that is challenged before this honorable court by way of this review petition.
But did you mention that in your anywhere that this Atarjan Akan is your mother anywhere?
No, your lordship. I have mentioned, I have gone through the written statement. It has been mentioned that Sahed Ali is my father. His name appeared in the voter list of 1966. My name appeared in the voter list of 1989. I have discussed nothing regarding Atarjan Akan, nor I have said that he is my elder brother.
What is the learned tribunal say? Let us
learned tribunal also took the same view, your lordship.
Why is that?
Your lordship will find the order starts from page 51. And your lordship will find
Yes.
it on page 52 below. From the said exhibit, that is exhibit B, your lordship, it is clearly established that all the above named persons, that is Atarjan Akan, Muslim Ali, and Hazrat Ali, are the sons of Sahed Ali. In the said document, the age of Atarjan Akan, Muslim Ali, and Hazrat Ali are shown as 57 years, 31 years, and 29 years. respectively. If the age of Atarjan Khan, Muslim Ali and Hazrat Ali were 57 years, 31 years and 29 years in the year 1989, then their age in the year 1966 would be 34 years, 8 years and 6 years respectively. Whereas Sahid Ali, son of Rahim, who is claimed as the father of the proceeding, is shown as 25 years in the year 1966, from which it is seen that Atarjan Khan, son of Sahid Ali, is 9 years older to Sahid Ali, who is projected as the father of the proceeding. Hence, it is proved that Sahid Ali, who is shown as the father of Atarjan Khan, Muslim Ali and Hazrat Ali, that is the proceeding, and Sahid Ali, son of Rahim, whose name is recorded as voter in the year 1966, are two different persons. So, the view taken by the tribunal as well as this honorable court, your lordship, that Atarjan Khan is my elder brother, is itself erroneous. She is my mother, your lordship. And with regard to other, your lordship, observation, your lordship, regarding the voter list of 1993, it is a certified copy that has been cleared by this honorable court, your lordship. That doesn't require to be proved, your lordship. In Mamta Bhonik, your lordship, this honorable court has made it clear. And the other fact, your lordship, it has been held that the summon issued to me was of 1966-71 stream. But when the tribunal, as this honorable court
Why
perused,
the summon?
someone I have not annexed, but from the order it transpires, your lordship. Your lordship, the last para. Last para 57. Page 57, last para. In the course of argument, Mr. Biswas made submission that in the notice issued by the tribunal, the petition.
আপনার জনাই যে শোণিতপুর জেলায় আরক্ষী অধীক্ষক আপনার বিরুদ্ধে 15 তারিখ ভিতর কোনো অবস্থায় প্রমাণ নেই।
Now,
Yes,
Yes, your lordship. Regarding that summon, your lordship, it has been then held, your lordship, by this honorable court. Though the summon was of the 1966-71 stream, but going by the reference, it was of post 1971. My humble submission in this regard is, your lordship. After I received the summon, I was of the view that I was of the 1966-71 stream. So if a summon ought have been issued regarding that projecting me as a post 71 foreigner, that my line of defense, my written argument, everything could have been different, your lordship. So the error committed by the tribunal, your lordship, has also affected me, your lordship.
are you given any copy of the inquiry report?
No, your lordship, nothing. Your lordship, what I am trying to submit here, your lordship, all these things, your lordship, the issuance of summon, the reference, everything is done so casually that, your lordship, this kind of, your lordship, errors takes place, your lordship.
Well, these are the arguments to be raised before the in the writ petition itself. And this the issuance of summon and etc. wrong mentioning of the stream in the summon, that issue has been settled by the honorable court. My learned friend also knows that matter. It is not that he doesn't know, but they used to argue the same point again and again. That is not, that cannot be accepted. First of all, what my submission is that the issue here is one more. First issue is delay of filing this review. My humble submission before your lordship. The delay issue is here, so that issue is to be settled first, whether the delayed filing of review can be accepted or not, So my they
Yes,
my
yes,
Your lordship, it was filed back in the year 2019. Your
no, that is the FT order was of 2016 21/6/2018, my lord. High Court orders of 30/12/2018. Then review filed after 6-7 months, my lord. 11/6/2019. The delay is nowhere explained, my lord, in the writ petition, in the review petition. That is the first issue, my lord. So, my lord, what my submission is that, my lord, my learned friend, Mr. A. Kalita, will
This is
argue that
2018. When did you file the review petition?
in the year 2019, your lordship.
11/6/2019. My lord, what my lord, the next bench is hearing the some other matters of same issue, delay in review, my lord. Mr. Kolita is supposed to argue that case, my lord, but he is in court number 1 now, my lord. Can it be taken, my lord, sometimes back, my lord, after the next bench decided the issue, my lord. Today he'll
Today?
argue in the next bench.
Huh? Next bench.
Yes,
Next
ma'am. Yes,
Today,
next
today has been fixed.
Yes, ma'am.
The
So that
only thing that my brother, I don't know when. This bench again may not sit also. We don't know.
so once the
But
issue
what is the delay? 3/12/2018, and when did you file?
In the year 2019, your lordship.
Which
11/6.
year 2019, which month?
11, he's submitting
11/6.
11.
You are the one who should know.
Lordship, I'll have to check it, your lordship.
What kind of, what checkup? Is your case, you don't know when it was filed.
Your lordship.
— 11/6/2019. Then apart from that, yes, any other issue, Mr. Pine?
My lord, other issues, my lord, if my lord, your lordship satisfied that review, first of all, then my lord, I can go on merit, my lord. That is the issue.
That's why he says the mother has been shown to be brother by the tribunal. The mother, what is that?
Atarjan Akan.
Atarjan Akan, who the petitioner claims to be her mother, has been
My lord,
treated to be a brother by the
my
tribunal.
lord,
That-
my lord, I will argue on merit,
Yes.
my lord. If,
Argu- Argu-
my lord, that issue is settled first, my lord. Because otherwise, my lord, the merit.
Have you have completed your argument? You have
Lordship,
completed your argument, you tell us.
Your Lordship, regarding the marriage,
Oh.
Your Lordship, I have completed my argument.
You have completed your argument.
Yes, sir.
Okay, very well. So your argument is not fine.
First of all, my lord, the grounds of reviews. What are the grounds of review here, my lord? My lord, the grounds of review, my lord, your lordship will find in the review petition at page 5, my lord.
Yes, grounds of review, page 5.
Yes. Yes, first, the ground is that there is error apparent on the face of the record, as such the impugn order so and so is liable to be reviewed. My lord, that what is the error apparent in the, my lord? That indeed, my lord.
Page.
Page 5 of the review petition.
Yes.
He has cited, my lord, this is a ground, first ground he has cited, there is error apparent in the impugn order dated 3/12/2018.
Hmm.
Of this honorable High Court, my lord. He has to show what is the error apparent, my lord. Review jurisdiction, as your lordship knows, my lord, they are unlimited. And, my lord, while sitting your lordship in certiorari jurisdiction, even in sitting certiorari jurisdiction, your lordship, our power is limited. And that is after, my lord, certiorari of the judgment in the certiorari jurisdiction, my lord. Again, we are going for a review of that certiorari order, my lord. Review of that certiorari order, how much it will be limited, my lord. Our limitation will have to, my lord, confine within the review jurisdiction. So, second thing, my lord, for the second grounds he has cited for the Atarjan Akon, who is according to the honorable court is elder brother of the petitioner is not correct, which may be clearly made out on a bare perusal of Annexure 3, that is voter list of 1989, which goes to show that Atarjan Akon is not a male, but a family relation with Shahid Ali. As such, the impugned judgment and order dated so and so is liable to be reviewed by this honorable court. My lord, this I will come, my lord. What is the, my lord, issue? And second, third ground for the minor discrepancies of the age of different members of the family. My lord, these are the issues which has to be argued in the writ petition, not in the review, because this is a fact which has been decided by the tribunal. We are not the review, my lord. We cannot say the, my lord, the High Court, this honorable court has committed, my lord, wrong. If this honorable court committed wrong, my lord, in their judgment or their order, my lord, that has to be challenged in the apex court. I have no problem on that. My lord, what the wrong has to be error apparent on the face of the record, my lord. These are on merit, my lord. The issue is on merit. What did the honorable court fails to appreciate the fact that Atarjan Akon is actually the mother of the petitioner and the wife of Said Ali, whose name is enlisted in the voter list of 1966. As thus, the impugned judgment and order is liable to be reviewed by this honorable division bench. So these are the grounds, my lord. So now his main ground is that, my lord, there is an error apparent on the face of the record. My lord, now your lordship may kindly see what is the judgment of this honorable court. He has cited that, my lord, the Annexure 3. This is an Annexure 3, my lord, that the mother has been shown as brother. Now your lordship may kindly see the judgment of this honorable court in the original writ petition at page 56, my lord. Heard Mr. So-and-so, learned counsel for the petitioner, Mr. G. Sharma, so-and-so, and so-and-so, so-and-so, so-and-so. Petitioner assailed the order dated 21/6/2018 passed by the Foreigners Tribunal, Tezpur, Assam, declaring him to be a foreigner who entered into India illegally from the specific territory of Bangladesh after 24/07/1971. To dispel the suspicion, he is a foreigner within the meaning of Foreigners Act 90, claimed relationship of one Shahid Ali, village Bhagat, village for LEC in his project as his projected father. To establish his linkage we produced and exhibited 3 documents,
You are reading page number,
56, my lord.
page 56. Yes. Yes,
To establish the linkage, he produced and exhibited 3 documents, namely the certified copy of the electoral roll of 1966, Annexure A, recording the name of projected Shahid Ali, 25 years. When Shahid Ali was there in 1966, the certified copy of the electoral roll of 1989, recording the name of the petitioner, aged about 29 years. And his 2 brothers, that is Atarjan Akon, aged about 57 years, and Muslim Ali, aged about 31 years, showing their relationship with one Shahid Ali and single voter digit certified copy of the electoral roll of 1993, recording the name of petitioner with relationship with Shahid Ali. Now, my lord, his only problem is that one Atarjan Akon, whose name has been enlisted in the voter list of 1989, my lord, aged about 57 years, is shown to be brother. And that has, my lord, his claim is that if this is shown as murder, then his claim will be, my lord, what his claim that he is the son of this, my lord, Shahid Ali, that will prove. His projection is that, my lord, if it is shown as murder, the instead of brother, if it is shown as murder, my lord, whether this wrong will, my lord, alter the entire judgment or negate the entire judgment, my lord. This only the brother, mother has become brother. Whether this will, and my lord, now your lordship may kindly see what is there in, we can, if you go on merit, my lord, your lordship may kindly see 1966 voter list, which is as exhibited as exhibit E. Whether this, my lord, 60, if it is in the record, my lord, what he has submitted in the record, my lord, that will be there in the record.
Yes, yes.
yes, yes,
Yes, my lord, it is in page 27 in the, my lord, the
yes.
review petition probability is in page 27, the running page, my lord. 28 is the vernacular. This is voter list of 1966, my lord. Here the only name is one Shahid Ali. One Shahid Ali, son of Rahim, aged about 25 years, is of village, my lord, Borghat. So, my lord, this is the basis, on the basis of which he is claiming, my lord, that my father was there or my family is there in India prior to 71. Now he has to link himself to this person, my lord. And his project is that by 89 voter list, my lord, in the as this honorable court has described, this, my lord, your lordship will find page 30 is the 89 voter list.
Yes.
Page 80, my lord. Now he is claiming that this 89 voter list, where his name is enlisted as, my lord, Hazrat Ali Akan, that is at serial number 294. He is claiming that he is this Hazrat Ali Akan of page 294 of page 30, and his mother is Atarjan Akan, my lord, 291 serial number, that has been wrongly described as brother of the petition. What difference will come, my lord, if it is described as mother? Had this mother, my lord, Atarjan Akon, name were appearing in the voter list of 1966, that could have been a different issue. But by altering this, my lord, if it is described as mother or brother, whatever it may be, it is of 1989 voter list, not of prior to 1971. There will be no difference at all, my lord. This Atarjan Akon, Muslim Ali, Kitab Jan, Hazrat Ali, Laluban, whoever it may be, man, they are in the voter list of 1989. 1989. By typical mistake or whatever it may be, my lord, the mother has, my lord, this woman has been declared as, my lord, woman has been wrongly typed as, my lord, male. That can be corrected. I have no problem on that. But, my lord, whether by correcting that, his claim will be fulfilled. Whether he can say, my lord, this Atajan is the wife of that Sahet Ali, who is there in the voter list of 1966. How can you prove? What is the proof? And this Atajan is 57 years in 1989. Her name should have been there in the voter list of 1966. She is very much eligible for voting in 1966. Where is this Atajan? She is very much eligible for voting because at that time the minimum age was 21 years for voting right, getting a voting right. So she was eligible to vote in 66, 70. Why her name is not there along with father? If her name was appears in the voter list of 1966 and 70, along with that one Sahed, whom he is claiming as father, then my lord, if this wrong could have some my lord, issues here. But as per my submission, my lord, this page 57, the brothers, my lord, instead of mother, has my lord, nothing to do about, or my lord, no way, my lord, since the entire issue, my lord, no way help the petitioner or the proceeding to establish that he is the son of this Sahed Ali.
Yes.
So this has nothing to do, my lord. Atajan account 57 years Muslim only. So that is his only grievance. Now, my lord, other issue my learned friend has raised. My lord, other issue my learned friend has raised, my lord, that in the notice, my lord, it was 66-71, but he was declared as post-71 because, my lord, it is a settled proposition of law by this honorable court that if the my lord, the references of post-71, only if in the notice wrongly it is, my lord, typed as 66-71, that will not, my lord, they will not affect the entire proceeding.
Judgment, any judgment?
That is judgment is there, madam. I can submit. That I will submit, my lord, but right now probably it is. He knows, my lord. It is not that it is also known by my learned friend. He knows it, my lord. This is a settled proposition. So, and that issue was dealt with by this honorable court in this order also, my lord. It is not that that issue was not dealt with.
And what did this court say in this about this issue? Though notice was issued, clearly mentioned the position conditions. He had not entered Assam. So you also taken a plea in written statement that he had not entered Assam after 25/3/1971.
That is clear. My lord,
You
that
also
has,
stated.
Yes, sir.
So it did not come after 25/3/71, but you came before that.
Yes, your lordship.
You came before that.
Yes,
So you are a Bangladeshi otherwise.
I'm in India, your lordship. If I have
But
come,
you say
if I have
you
come
did not
bef-
come after 25/3/1971,
Yeah, I have
but
come
you
before.
came before.
Yes, your lordship. Since I have come before 25/3/1971, me or my parents, your lordship, I am an Indian citizen, your lordship.
Oh.
Your lordship, if I submit, your lordship, now my
Anyway,
Hold
we
the
will hear you. Don't worry. We'll complete hearing.
my lord, so there
Yes.
is, my lord, the second issue, my lord, the first, my lord, my lord, this is 2017 2 GLT 996, my lord. Anand versus Union of India. 2017 2 GLT 996. Two 2017 2 GLT 996.
Yes. There
Matlab, para 13 में same matlab. It's para 1-3. Matlab, may I read, matlab? Having regard to the above, we have no hesitation to hold it when the reference was as to whether the petitioner is a foreigner belonging to post 1971 stream, non-mentioning of the same or wrong mentioning of the stream of foreigner to which the petitioner belonged in the notice would not vitiate the ultimate conclusion reached by the tribunal that petitioner was a foreigner of post 25/3/1971 stream. Since the reference was assured in the favor of the state, it ought to have been, has rightly been ensured in the above manner. So this is settled, matlab. And it is known, matlab, it is not that my learned friend doesn't know it, matlab. This, and this is a settled position, this is known to it. Now, matlab, grounds of review. Sorry, whether the review can be, matlab, used as a rehearing of the writ petition or matlab. These issues were not, it is not that matlab, these issues were not before the tribunal, matlab, writ court or in the matlab tribunal. These issues were there. Only matlab, to this matlab, the Lordship, we have authority of Supreme Court, my lord. This is 2013 8 SCC 320.
2000.
2013 8 SCC 320. This is Kamales Burma versus Mayawati and others, my lord.
Yes.
My lord, in that case, my lord, it was a long discussion. After long discussion, my lord, some summary principles were laid down by the Honorable Apex Court. Your Lordship may kindly see there is para 20 onwards, my lord. These are the principles laid down by the Supreme Court, my lord. After it has discussed lots of judgments, my lord, but some principles have been there. Summary of the principles, my lord. Thus, in view of the above, the following grounds of review are maintainable as stipulated by statute. When the review will be maintainable, my lord. 21.
Yes.
Discovery of new and important matter or evidence which after the exercise of due diligence was not within the knowledge of the petitioner or could not be produced by him. Well, there is no discovery of new facts or new things here. Mistake or error apparent to the face of the record. Where is the error apparent to the face of the record, my lord, or mistake? Any other sufficient reasons? My lord, this reason, the words any other sufficient reason have been interpreted in so-and-so and approved by this court in so-and-so to mean a reason sufficient on grounds at least analogous to those specified in the rule. The same principles have been reiterated in so-and-so, so-and-so. When review will not be maintainable, review will not be maintainable. 20.2, this is a repetition of old and overruled argument is not enough to reopen the concluded adjudication. These issues were, my lord, argued in the jurisdiction, my lord. This cannot be repeated here again and again. This is already, my lord, settled. Minor mistakes of inconsequential import. My lord, the mother has been wrongly typed as brother. It is a minor mistake and it will not, my lord, way inconsequential. It will not affect the entire judgment. Had the mother's name was there in the voter list of 1966 along with father, well, that could have been. But otherwise, it's a voter list of 1989 post-71 document. It has no rule to play. review proceedings cannot be equated with the original hearing of the case. Matlab, review proceeding cannot be equated with the original hearing of the case. Second, review is not maintainable unless the material error manifest on the face of the order, undermine its soundness, or results in miscarriage of justice. This will not affect anyway. The mistake of brother, word brother will not affect anyway. A review is by no means an appeal in disgust, whereby an erroneous decision is reheard or corrected, but lies only for patent error. The mere possibility of two views on the subject cannot be a ground of review. My lord, his submission is that 66, 71, and some minor, he has also given him, so there are some minor, my lord, age discrepancies, so that cannot be accepted. These are, my lord, repeated arguments. These arguments were there in the review petition, read petition. Even this, my lord, this is, there cannot be, he cannot say this should, if it is accepted in this way, the judgment would have in our favor. But it is accepted in this way, so it has gone in against us. That cannot be done in review, man. That cannot be done in review. The mere possibility of two views on that subject cannot be a ground of review. The error apparent on the face of the record should not be an error which has to be fished out and searched. The error should be, my lord, error apparent. It cannot be fished. It cannot be in such a manner that it should be fished out. The appreciation of evidence on record is fully within the domain of the appellate court. It cannot be permitted to advance in the review petition. Even we cannot go for the appreciation of evidence. We cannot go for any appreciation of evidence. Review is not maintainable when the same relief sought at the time of arguing the main matter had been negative. This, my lord, 66, 71 stream that was argued, that was negative. So these are the principles, main principles, my lord. Even thereafter also 2022, this is latest judgment, my lords, of the Honorable Apex Court. 2022 SCC online SC 1034. This is in the same line, my lord. This is in the same line, my lord. My lord, our High Court also in numbers of cases, even in the, my lord, the same principle has been followed in foreigner tribunal cases. My lord, through one of the judgment, this is of our, this Honorable High Court Supreme, my lord. This is review petition number, my lord, 70/2021, disposed of on 3/3/2022.
This one, you minute. Yes, Mr. Pai. Which
My
one?
lord, this is Jamaluddin. This is review petition number 70 of 2021.
Judgment, is there guilty? No,
No,
not
this is
reported.
recently disposed of, my lord, on 3/3/2022.
Just see that. 332, no, maybe it is in the CIS.
Yes, yes.
Maybe in the CIS.
Yes, review petition number 70 of 2021. 70 of 2021. Disposed of on 3/3/2020.
Scroll down, scroll down.
My lord, may para 11 may be seen. my lord.
Yes.
Para 11. Yes, may I read the my lord? The issue, my lord, why I'm reading, my lord, the issue is here also in this case, my lord. The court has noticed that at the outset, the present review has been filed by a set of lawyers who were not the counsel in the writ petition. The Honorable Court in the case of so-and-so, 1997 9 SCC 736, has depreciated the practice of preferring review by sins of lawyers. My lord, this has to be seen, my lord, because in the writ petition they argue in some ways, and by changing lawyers, but they argue in other ways. My lord. They say that is the practice in the review petition. So this has been depreciated. Now, however, even by overlooking the aforesaid aspect of the matter, the court is of the view that to maintain a review petition, my lord, the same issue, same points have been accepted, my lord. The condition precedent have to be there, that is error apparent on the face of the records, discovery of new facts, which were not within the knowledge of the review applicant, and would have a material bearing in the adjudication, and thirdly, for any other sufficient reasons. My lord, the mistake I accept, my lord, the mother has been typed brother in the judgment of the Honorable Court. That will no way, my lord, affect or bear that will bearing any kind of bearing in the adjudication. That is the only point he is, my lord, what he is trying to, my lord, introduce newly, or my lord, argue in the present review petition. Otherwise, all the other issues, my lord, they have resorted in the writ petition. All the other issues, they have resorted in the writ petition. Only here is, my lord, only their argument is, new point is that, my lord, the mother has been described as, my lord, brother. That will, my lord, as I have submitted already, my lord, from the facts and circumstance of the case, from the documents, my lord, there is no bearing of any, my lord, adjudication. Well, there is no problem. It can create any problem, my lord, in the interest. That is.
That's all.
Yes, there are, my lord, judgments of this Honorable Court where, my lord, it is accepted this review jurisdiction of in the writ petitions. My lord, same principle will apply whatever there is in the, my lord, civil procedure. So the Kamalesh Burma has, my lord, Kamalesh Burma and the Supreme Court, whatever laid down by the Honorable Apex Court, that will come into play.
Yes, sir.
Yes, Your Lordship, my humble submission, Your Lordship. Now whether there was an error apparent on the face of the record, which he has before this court, Your Lordship. Yes, Your Lordship, there was an error apparent on the face of the record. The mere perusal, the bare perusal of the voter list of 1989 shows that it was a part of the record, And in that record, your lordship, in the gender column, it has been clearly stated that Atarjan Akan is a female, not a male. And that has been appreciated wrongly by the tribunal. And even if this honorable court has taken the same view, your lordship, and whether that will have any material effect in adjudication of this case, yes, your lordship. If your lordship peruse the order, your lordship, just because Atarjan Akan has been declared as my, has been projected as my elder brother, your lordship, the entire nature of the order changes. And it has been held by this honorable court, your lordship, that my elder brother cannot be elderly to his father. So your lordship, just because of this point, your lordship, and the nature of the order changes, your lordship. So there was an error apparent on the face of the record, and this error apparent has an material bearing on the adjudication of the case, your lordship. That is my humble submission, your lordship. I'm only on that, your lordship. And your lordship, whether my learned friend, your lordship, has said, has argued that, your lordship, in a bench of certiorari, whether your lordship can go ahead, your lordship. My humble submission is that, your lordship, the power of this honorable court under Article 226 very wide. And when, your lordship, such an error has taken place, your lordship, on the face of the record, your lordship may interfere for rectification of the error and the effect that has, and the material bearing that had taken place on the adjudication of this case, your lordship. And with regard to this, your lordship, 6671 stream, he said, I know, your lordship. He also knows the Muslim Mandal case, your lordship. In para 78, it has been clearly stated that the tribunal cannot go beyond the reference, your lordship. And your lordship, after 2016-17, there has been order of this honorable court, which has, where it has been held, your lordship, the tribunal cannot travel beyond the reference, your lordship.
It's true. We are not saying that we are going beyond reference. We are accepting the reference. Only the issue is that there was wrong mentioning of the stream in the notice, not the reference.
What I'm saying, your lordship, the order he has highlighted is, your lordship, produced before this court, your lordship. The conclusion of the foreigners tribunal cannot, the reference cannot vitiate the conclusion of the foreigners tribunal, your lordship.
And Mr.
I say.
I Hussain Learned Counsel for the review petition. How does Mr. Point for the?
My lord, before going, my lord, only one more point, my lord. As your lordship, my learned friend is arguing on mainly on one point, my lord, that his brothers has been shown more brother and mother. My lord, whether that issue was raised before the my lord, my lord, dishonorable court at the time of writ petition. Your lordship may kindly see the writ petition is annexed there in the my lord review petition. If that is
Please.
from page 17 onwards, it is his planning, my lord. Page on a para 1, my lord, he has described he is a citizen of India. That assertion. Then petitioner begs to state the name of the petitioner grandfather is lost at so. The petitioner begs to state the name of the father of the petitioner is Sahid Ali, appeared in the voter list of 1966, shifting of the village. Then the petitioner begs to state the petitioner was born and brought up in the village so-and-so, then district so-and-so. The name of the petitioner appeared in the 1989 in the subsequent row so-and-so. The petitioner begs to state that the government, however, has issued certificate. The government then, my lord, upon reference of the matter in the reference so-and-so, foreigners proceeding application number so-and-so was initiated against the petitioner being so-and-so. The petitioner next, my lord, the learned tribunal foreigner by the impugn judgment and order that so-and-so stated the petitioner has failed to establish link with her projected father, so-and-so, who is my lord. Then, my lord, para 8, the petitioner begs to state that he was not present when judgment was delivered. Then, para 9, that the petitioner begs to state the petitioner had exhibited the certified copy of electoral roll of the learned foreigners tribunal illegally arbitrarily failed to take into consideration of the same to fill the another documents in his brother, so-and-so. Like 66, he has relied. 89 voter list he has relied, shown that the petitioner is the son of Sahid Ali, whose name appeared in the voter list of 96, and grandfather of so-and-so, recording so-and-so. Then exhibit C, the voter list of 1999 also alleged ground of discrepancy of death through so-and-so, whose name appeared in 19 so-and-so. That is, my lord, he has nowhere raised that issue in the court. Now, after decision, my lord, when the decision has gone against him, He has nowhere mentioned even his mother's name. And now he is arguing that new point, my lord, which will come under the constructive res judicata. The constructive res judicata that will not allow him to bring a new ground in the manner in the new set of proceedings. Because had this issue have been argued in the writ petition, my lord, this is not even pleaded in the writ petition. Now he is saying the High Court has committed error, this honorable court has committed error. Where is the pleading? He has not given a single word of that pleading. So that's why, my lord, the changing of lawyers in the review petition is most dangerous. That's why the honorable apex court has, my lord, in that case, has depreciated the, my lord, this same, my lord, the another lawyer will come, he will take a new issue. Another lawyer will come, he will take a new issue. So this pleading was not before this honorable court prior to this matter. And now he is raising it only in review that this High Court has committed error.
Your Lordship, I would like to clarify, Your Lordship. I have not said that High Court has made an error. I have said there is an error apparent on the face of the record, Your Lordship. I have submitted that, Your Lordship. And Your Lordship, regarding the pleadings, Your Lordship.
This is a review filed against the order of this honorable court,
Yes,
not of the tribunal. You
Yes.
go to the tribunal and file a review there. If it is, it has to be corrected by the tribunal.
Your Lordship.
If it is to be corrected by this honorable court, then you are asking for the review of this honorable order.
Yes, that-
Review of the order of this honorable court, not of the tribunal.
I'm.
First of all,
I'm
Your
within
Lordship,
the
we have to
ambit of the
satisfy
law of this land, Your Lordship.
whether this honorable court has committed error.
I'm within the ambit
In
of the
his
law of this land.
Without pleading, he cannot say my lord, di situ.
Mr. We counsel for the counsel for the review petitioner, also Mr. Pine, for the respondent, state respondent, huh? 2, 3, 2, 5, and 6. B Das, yeah, B Das. With B Das, huh? Huh? Sorry? That earlier was respondent. Udas, no? Udas for?
For my last, the respondent number 5.
Respondent number 5. And the 3, 3, 3.
3 is AI Ali.
ARB. And LDB
4 man.
4.
1 and 4.
1 and 4. 1 and 4. In this review petition, the review petitioner has challenged has sought for review of the order passed by this court on 3/12/2018, by which the writ petition the writ petition filed by the review petitioner, WPC number 5/888 of 2018, challenging the order dated 21/6/2018 passed by the Foreigners Tribunal, Tezpur, First Assam in FT case number 301/2016 was declared him to be a foreigner who entered India illegally from the specified territory of Bangladesh after 24/3/1971. Before we enter into the merit of the case and rival contentions raised, consider rival contentions submitted before us. We will reproduce the order passed by this court on 3/12/2018, which is sought to be reviewed, as the same is not is a short and a brief. Type kora, page 56, hard sciences, huh? The basic contention of the review petitioner is that the aforesaid order would plainly indicate that the this court in WPC number 5/888 had dismissed the writ petition primarily on two grounds. The first ground, that the voters list of 1989 shows the name of one Atarjun Akon, age about 57, along with other brothers of the petitioner. Who 57, and the name of the said Atarjan Akon does not appear in the voter list of 1966, which has been relied upon by the petitioner, is containing the name of his father, namely Syed Ali. And since the said Atarjan Akon has been shown to be 57 years, who is stated to be his elder brother, he would be 34 years in the year 1966 when the age of his father, Syed Ali, shown in the electoral roll of 1966, was shown as 25 years, which is not possible, as the elder brother of the petitioner could not have been older than the father of the age of the father of the petitioner. It was also observed that as far as Exhibit C is concerned, what is Exhibit C?
The voter list of 93.
93, the same is a digitally issued document and not proved in accordance with law. Hence, this court also took the view that the petitioner had failed to establish his linkage with Syed Ali of 1966. This court observed that there is inherent impossibility where Atarjan Akon, elder brother of the petitioner, appears to be older than the projected father Syed Ali. Next para. This court also considered the submission advance that while the petitioner was suspected to be a foreigner entering India within 1/1/1966 to 25/3/1971 stream, the finding of the tribunal was that he entered India after 24/3/1971, and as such, the tribunal had travelled beyond the terms of reference. This court, however, after perusal of the case records, from the tribunal observed that although the notice issued by the tribunal made mention of the said aforesaid stream of 1/1/1966 to 25/3/1971, documents relating to the interrogation report and reference made by the concerned SP border clearly mentions that the petitioner was suspected to have entered illegally after 25/3/1971. And as such, in view of the above records, the submission was held to be without merit. And accordingly, that this court declined to interfere with the opinion of the tribunal. It is a case of the petitioner that from the above, it is quite apparent that this court had upheld the finding of the learned tribunal, which according to the petitioner is vitiated simply on the ground that there is error apparent on the record, in as much as the learned tribunal also wrongly considered the said Atajan Akon as his brother, though in effect the said Atajan Akon is his mother. In this regard, Mr. Hussain, Hussain Learned Counsel for the Regime, has drawn our attention to the finding of the learned tribunal. In the learned tribunal also has given the observation the learned tribunal, while going through the opinion of the learned tribunal dated 21/6/2018, which was by the Foreigners Tribunal Tezpur First, rendered in FT case number 301/2016. We also have noted that the learned tribunal had taken into consideration, had considered the said electoral roll of the year 1966 and the 1989. The learned and they gave the following and made the following observation. Para 6, which are reproduced here in below. Para 6, 7, Para 6 and 7. Thus, from the above, the learned tribunal also took the view that Atajan Akon from the above, it is quite evident that the tribunal treated Atajan Akon as a son of Sahed Ali, one of the sons of Sahed Ali, where the age of the said Atajan Akon has been shown as 57 years. The tribunal also made observation that if Sahed Ali, who the petitioner claims to be his father, was 25 years in 1966, Atajan Akon, who is the son of Sahed Ali, would be 9 years older to Sahed Ali, son of Rohim, who is projected as a father proceeding, which is not possible. And as such, the learned tribunal held that it is proved that Sahed Ali, who is shown to be the father of Atajan Akon, Muslim Ali and Hazrat Ali, that is the proceeding, and Sahed Ali, son of Rohim, whose name is recorded as voter in the year 1966, are two different persons. Next para. We have also noted that the learned tribunal also made certain observation about the Exhibit C, which is a digitally certified copy of the electoral roll, which are also not considered on the ground that it is a digitally issued document and not proved in as required under law. Learned Tribunal also made another observation that though the proceeding claimed that he had shifted from village Borghat to his present place of residence, he did not produce any document nor any witness to prove that he was originally residing in village Borghat. Next para. The learned tribunal also took into consideration the plea raised by the proceeding that while the notice issued by the tribunal mentioned that he had entered Assam between 1/1/1966 to 25/3/1971, but in the present reference, it is clearly mentioned that the proceeding is staying continuously in India after 25 March 1971. However, the tribunal also noted that the proceeding himself has taken a plea in his written statement that he had not entered Assam after 25/3/1971 without any valid document. NSS did not give any importance to such a plea raised. And accordingly, the learned tribunal declared the present petitioner to be a foreigner who entered India illegally from the specified territory of Bangladesh after 24/3/1971. Next para. Learned counsel for the petitioner submits that a bare perusal of the voter list of 1989 would show that Atajan Akon has been shown as the wife of Sahed Ali, and in the column number 5, indicating the gender of the person, it has been clearly mentioned to be a female. If that is so, the tribunal could not have proceeded with the assumption that Atar Akon is the son of Sahed Ali. Had Atajan Akon been a son of Sahed Ali, the name would have been, the gender would have been reflected as male. And accordingly, it has been submitted that this is an error apparent on the face of the record, is the observation of the learned tribunal as well as of this court that Akon Atarjan Akon is a son of Sahed Ali is contrary to the record which is plainly visible. This court also, while dismissing the appeal, dismissing the writ petition WPC number page number 55. While dismissing this petition, WPC number 588 of 2018 also proceeded on the assumption that Atajon Akon, age about 57, was a elder brother of the petitioner. And as such, and this belief, and on the ground that the elder brother of the said Atajon Akon, the elder brother of the petitioner, could not have been older to his projected father Sahed Ali. The court proceeded to hold that this court also proceeded to hold that the Sahed Ali as projected as mentioned in the electoral roll of 1966 and Sahed Ali as mentioned in the electoral roll of 1989 are different persons. Full stop. It has been submitted that because of the aforesaid error committed by the tribunal as well as by this honorable court in appreciating the identity of the said Atajan Akon, who is otherwise shown to be female in the records, the entire opinion of the tribunal as well as by the decision of this court will stand vitiated, and on that ground only the review, on the ground only, the order passed by this court on 3/12/2018 would warrant review in which event and also setting aside the setting aside the order of the tribunal. To stop. And in response, Mr. Pine has vehemently, he has strongly resisted the review petition. It has been submitted by Mr. Pine that normally, even a writ petition challenging the opinion of a tribunal, it has been submitted that even the scope of this court in entertaining any petition challenging the opinion of tribunal is limited. Inasmuch as this court exercises the writ of certiorari to examine the validity of opinion of a tribunal, which itself, and it is well settled that the scope of writ of certiorari is limited. And since a review has been sought of an order passed by this court, obviously the scope of such review petition would be much more restricted. It has been also submitted that the grounds taken by the petitioner for review is to be found in para number is mentioned in the petition are as follows. A, B, C, page number 5-6. Referring to ground A, it has been submitted that though the petitioner submits that there is error apparent on the face of the record in the impugned order dated 3/12/2018, it has not been explained, enumerated as to what is that error which is apparent on the face of the record. Thus the failure, full stop. Further, the ground be taken by the petitioner that Atajan Akon, shown to be brother of the petitioner by this court, is not correct, as Atajan Akon is not a male but a female. However, it has been submitted that while taking that plea, while the petitioner has taken the plea in his review petition, he had not taken such a plea when he filed a writ petition in WPC number 5 in 5/8 of 2018. In this regard, Mr. Payang has led us through the pleadings of WPC number 588 and has submitted that there is not a paragraph in a said writ petition WPC number 588 of 2018, wherein the writ petitioner has taken this plea that Atajan Akon is not a male but a female. And as such, this ground cannot be raised in the review petition, as it will be hit by constructive res judicata.
Only one point, my lord, I want to add along with this, my lord. My lord, this is not a new fact coming to the, my lord, known to the by the petitioner after the, my lord, at this stage. This fact was known to him even prior to filing of the writ petition.
Petitioner, Mr. Payang submits that this is a fact which has, this is not a new or which is new or discovered only now. It is a fact which has already to the knowledge of the petitioner while filing the earlier writ petition 5/8 of 2018.
Because the issue
And
that was
as
discussed
in as
in
much
the
as the said decision, the said issue was already, in as much as the learned tribunal has already made a decision on that based on the aforesaid facts. And as such, the petitioner cannot raise this plea in this review petition. Further, as regards the other ground taken that that minor discrepancy in age of different members cannot be rejected, comma, it has been submitted that unless such a error leads to a substantial miscarriage of justice, that cannot be a ground. Full stop. It has been further submitted that. The present petition is also hit by delay and laches. It has been submitted that while the order was passed by this court in WPC number 5/8 of 2018 on 3/12/2018, the review petitioner preferred this review petition. The petitioner preferred this review petition only on 1/6/2019. 11/6/2019. And I said there has been a delay in preferring this review petition. Next one.
That is not explained in the.
And this delay has not been also explained before this court. Next one. Mr. Pine submits that this review petition cannot be used for the purpose of rehearing of matters which have been already considered by this court in WPC number 5/8 of 2018. In this regard, Mr. Pine also has relied on the decision of the, what is this, 2017 volume 2 GLT?
That was, my lord, regarding that notice.
Okay, notice, okay.
Notice.
Then in this regard, Mr. Pine has relied on the decision of the Supreme Court in 2013, that one?
Yes, my lord.
2013 volume 8 SCC 320.
Yes, straight.
Kamlesh Verma versus Mayawati and others. Referring to the aforesaid decision, wherein the Honorable Supreme Court had reiterated the principles governing review, has submitted that a review will not lie unless there is, unless there is error apparent on the face of the records. Further, a review will not be maintainable if there is a repetition of old and overruled argument, or the minor, if the mistake is a minor of inconsequential import. And the error apparent on the face of the record should not be an error which has to be fished out and searched. In this regard, Mr. Pine has drawn attention to para 20 of the aforesaid decision, which reads as follows. It has been submitted that the next page, it has been submitted, Mr. Pine, that in fact what is sought to be done in a review petition is to bring a new argument that there was a mistake, by the error by the tribunal in showing his mother as the elder brother, and elder brother, which according to the petitioner has vitiated the opinion. However, Mr. Pine submits that submission would be of no consequence in as much as in the voter list of 1966, the name of the said Atarjan Akon is not shown as the mother of the petitioner or the wife of Sahed Ali. It has to be proved by the petitioner that said Atarjan Akon is a mother and hence a female. Therefore, even if the tribunal had made an error by treating the said Atarjan Akon as a male, it will have no consequence in as much as the petitioner has to prove that the said Atarjan Akon is her mother.
In earlier line, my lord, is a mother and was a resident of India prior to 7.
And also that her mother, the said Atajan Akon, was a resident of India prior to 1971. Thus, having not established merely because the tribunal had made that aforesaid error cannot be a ground for seeking a review. It has been submitted that the fact that a party cannot introduce new plea in a review petition has been also reiterated in a subsequent decision of the Honorable Supreme Court in 2022
Yes,
is
madam. 2022
online Supreme Court 1034.
SCC
2022 SCC online
SC
Supreme Court SC 1034. It has been submitted that what the petitioner is seeking to do is by bringing the aforesaid ground he is seeking to change the entire judgment in his favor. If the plea of the petitioner is to be accepted at this stage, it would change the entire opinion of the tribunal as well as of this court, which is not permissible to be raised at this stage. It has been also submitted that raising new pleas by changing of lawyers has been also deprecated by the Honorable Supreme Court in the aforesaid decision in
This is my lord, 1997 9 SCC 736.
in the decision of the Supreme Court in 1997,
9 SCC 736.
1997, 9 SCC
736.
736.
That has been reproduced by this honorable court in matter of this review petition 70/2021, para 12, 11. Relied by this honorable court.
There are 12.
Yes, para 12 of review petition 70/21. 3/3/20. Para 11, sorry. Para 11.
Oh, okay. Okay. Oh, is this? Which have been referred to by this court in review petition 70 of 2021, within bracket, Jamaluddin versus Union of India and others, comma, disposed of on 3/3/2022. Next. Mr. Payang also submits that a submission advanced by the petitioner that the tribunal cannot go beyond the term of reference has been already also considered by this court in a decision in so and so. What is the name?
2017 2 GLT 996, madam.
Name of the party?
Ananda Ghosh.
Ananda Ghosh versus Union of India, comma,
That is-
2017, volume 2, GLT 996.
That is, my lord, not beyond the reference, my lord. That is, my lord, wrong mentioning
Okay.
in the notice. my lord.
I think that the wrong mentioning of the
Stream in
the stream in the notice
Yes,
does not vitiate the proceeding
if reference is correct.
if the reference is otherwise correct.
Yes.
And in the present case, as also observed by this court, the record would show that the petitioner had entered India after 24/3/1971. And as such, it has been submitted that said ground, which has been already argued, cannot be taken before this court in a review petition. Accordingly, it has been submitted that the review petition is not maintainable and deserves to be dismissed. Next pair. Having considered the above submission in the light of the reports which have been produced before us, in review, the two issues appear to be as before us to be considered. First of all, whenever a review petition is filed, this court has to examine as to whether such review petition comes within the scope of a review. Without going in detail, the legal position, it is settled and well accepted that a review would be permissible and would lie, and such petition would be, a review would lie, would be review, an application for review will be maintainable if the review petitioner is able to show that there is error apparent on the face of the record. In fact, this is the plea which has been taken by the review petitioner in this present case. Therefore, we will first examine this plea as to whether there is apparent on error on the if there is any error apparent on the face of the record. We have given our anxious consideration on this issue and perused the original records ourselves. In the original record, what we have noted is that the petitioner had relied on two voter lists, apart from three voter lists, of which two are of importance. That is the voter list of 1966 and a voter list of 1989. The said voter list of 1966 relates to records the name of one Sahed Ali as a son of Rahim, shown as a male who is about 25 years, belonging to Borghat.
Village Borghat.
Huh?
Village Borghat.
Like the village Borghat. Village Borghat of Mauza Gorimari, Police Station Tezpur, District Dorang, Subdivision Tezpur of 78 number Balipara Legislative Assembly Constitution. The other voter list, we have the certified copy of the voter 1966. The other voter list is a certified copy of the voter list of 1989, which shows the following names, including the name of the present petitioner Hazrat Ali. In a said voter list, the name of Atarjan Akon has been shown as the wife of Sahed Ali. And in the column indicating the gender, it has been shown as female. The said voter list also relates to Borghat. It also relates to Co-Borghat, within Borghat Co-Borghat of Co-Borghat of Mauza Balipara, Police Station Rongapara, Subdivision Tezpur and District Sonitpur. The plea of the petitioner is centered around this entry of the name Atarjan Akon. Certainly, the documents, the original document which has been produced before us and which are exhibited before the tribunal as Exhibit B, shows the name of Atarjan Akon with Sahed Ali as a female. Therefore, we are of the prima facie view that the said Atarjan Akon, shown along with Sahed Ali, is not a male but a female. The question which arises before us is whether such an error is apparent on the face of the record. and whether such an error is of such nature which will have a serious repercussion or consequence for the decision of the authority concerned. As reproduced above and discussed above, it is a specific finding of the learned tribunal that is quoted tribunal that Otarjan Akon, Muslim Ali and Hazrat Ali are the sons of Sahid Ali. This is a finding of fact. Similarly, this court also made an observation in the order dated C-12/2018, which is sought to be reviewed, that electoral roll of 1989 Exhibit B records the name of the petitioner aged 29 along with his two brothers, that is Atarjan Akon aged 57 years and Muslim Ali aged 31 years, showing their relationship with one Sahid Ali. This court also observes, the tribunal also observed that if the ages of Atarjan Akon, Muslim Ali and Hazrat Ali were 57 years, 31 years and 29 years in the year 1989, then their ages in the 1966 would be 34 years, 8 years and 6 years respectively. From which it is seen that Atarjan Akon, son of Sahid Ali, is 9 years older to Sahid Ali, son of Rohim, who is projected as the father of the proceeding. Accordingly, the learned tribunal held that it is proved that Sahid Ali, who is shown the father of Atarjan Akon, Muslim Ali and Hazrat Ali, that is Prosidi, and Sahid Ali, son of Rohim, whose name is recorded as voted in the year 1966, are two different persons. From the above, it is clearly evident that by treating the said Atarjan Akon as a elder brother of Prosidi, the tribunal came to a definite conclusion that Sahid Ali, which is shown in the voter list of 1966, is different from the Sahid Ali which is shown in the voter list of 1989, on the ground that the projected elder brother, the petitioner, could not have been older to his projected father. This is also the view taken by this court when this court passed the order on C-12/2018. From the above, it is clear that the finding of this tribunal as well as this court that the projected father Sahid Ali, whose name is recorded in 1966, is different from the projected father whose name also reflected as the father of the petitioner in 1989, are different and not the same person. In fact, that is the basis, that is one of the grounds for declaring the petitioner to be a foreigner. If that is so, we are of the view that such a finding by the tribunal as well as by the court goes to the root of the very proceeding. The proceeding obviously was initiated against the petitioner to ascertain about his doubtful citizenship as to whether he is an Indian or a person who had come from the specified territory during the aforesaid period mentioned above. The opinion by the tribunal was in favor of the state on the ground that the petitioner has failed to prove that he is indeed the son of Sahid Ali, who whose name is also found reflected in the voter list of 1966. Obviously, if Sahed Ali, whose name is found in voter list of 1966, is not the same person whose name also appears in the voter list of 1969, 89, it can certainly lead to the conclusion that the petitioner has failed to prove that he is the son of any person who was in existence in this country since at least since 1966. Therefore, in our opinion, the said finding is of consequence as far as the citizenship of the petitioner is concerned. To the extent we are of the view that the said error committed by if that is an error which has been, if that is the position of drawing an inference which the petitioner claims to be an error, we have the view that that would fundamentally change the nature of the proceeding in as much as it will determine the citizenship of a person. To that extent, we have the view that the aforesaid decision by the learned tribunal as well as by this court would have a far-reaching consequence as far as the present petition is concerned. The question, therefore, which arises for consideration is whether the said error is an error which is apparent on the face of the record. Having gone through the original record ourselves, we are of the view that that it is clearly that the finding by the learned tribunal as well as by this court that the said Atajon Akon is the elder brother of the Said Ali is not based on record but contrary to the record. In fact, Atajon Akon has not been shown to be a male but shown to be a female. Further, before the learned tribunal comes to a decision that Atajon Akon was a brother of the present petitioner, Hazrat Ali, it should have been based on certain evidence. From the records, we do not see, however, that the petitioner has pleaded specifically in his written statement that Atajon Akon is his mother. If the petitioner has not pleaded, nor that Atajon Akon is his brother. Therefore, if the petitioner has not specifically pleaded that Atajon Akon is his brother, or that she is mother, obviously, the finding of the tribunal must be based on some evidence on record. We have also gone through the record and seen that while the petitioner gave his written statement and the evidence, he was not subjected to any cross-examination to the effect that as to the identity of the said Atajon Akon. Therefore, there cannot be any basis for drawing the conclusion by the learned tribunal that Atajon Akon is the brother of the present petitioner. Though there is an element of doubt as to the real identity of Atajon Akon, inasmuch as the petitioner also did not specifically mention in his written statement nor in the evidence. Yet, this does not distract from our view that the tribunal at the same time could not have taken a view that that Atajon Akon is the brother of the present petitioner in absence of any specific evidence or pleading by any party. From the record, it is seen that the state did not lead any evidence, though it is well settled that it is primarily the onus of the proceeding to prove that he is a citizen of this country or that he is not a foreigner. Yet, it does not divest the state from any responsibility, as also observed by the Honorable Supreme Court in Sarvanda Sonowal versus Union of India 2005, Volume 5, SCC 665. In para number 29 of the decision, aforesaid decision, the Honorable Supreme Court 26. Well, that the Supreme Court observed that in order to establish one's citizenship, normally one may be required to give the evidence of his date of birth, place of birth, name of his parents, their place of birth and citizenship. How and once, as these are facts which would necessarily be within the personal knowledge of the person concerned and not of the authority of the state. The Honorable Supreme Court further went on to observe that after he has given evidence on these points, the state authorities can verify the facts and can lead evidence in rebuttal if necessary. Therefore, therefore, nothing prevented the state from leading evidence or rebut this evidence of the petitioner. However, there is nothing. What we want to say is that there is no evidence to the effect either by any of the sides, either from the side of the petitioner through cross-examination or by leading evidence by the state that the said Atarjan Akon is the brother of the present petitioner. Accordingly, we have the view that the identity of the said Atarjan Akon, which is shown to be a female in the voter list of 1989, could not have been treated to be the elder brother of the present petitioner. To that extent, we are of the view that there is error apparent on the face of the record. Under the circumstances, full stop. Under circumstances, we are of the view that it may not be necessary to go in detail about the finding arrived at by this court in WPC number 3995988 of 2018 or by the tribunal. In as much as if there is error apparent on the face of the record, which has serious consequences for the determination of the citizens of the country, we have the view that review would lie. Full stop. However, that goes to the next issue as to whether the review petition which has been filed in June on 11 June of 1919 is belated. We have noted that the order of this court was passed on 3/12/2018, and as mentioned above, the review petition was filed on 11 June 2019. Yes, there is certainly a delay of 6 months. However, this court is sitting, exercising the jurisdiction under 226 of the Constitution. And we do not feel that the said delay cannot be said to be so enormous of such consequence that the petitioner would be denied entry and denied approaching this court on the ground of delay of 6 months. Next one. We, however, do not make any observation as to the finding by the learned tribunal as well as by this court that the wrong mentioning of the period of entry in India and in the notice would vitiate the proceeding. We have also kept in mind the observation made by this court in 2017,
Yes.
Volume 2, GLT 996, name of the party, and so. But we also mindful of the fact that if the proceeding, in a proceeding, if the only document given to a proceeding is the notice that he is a foreigner and that he had entered Assam between 01/01/1966 to 25/3/1971, then obviously the notice is to the fact that he is an entrant, illegal entrant between the aforesaid period, which will have a different consequences for those people who are alleged to have entered Assam after 25/3/1971. Whether the wrong mentioning of a proceeding ultimately vitiates the proceeding has been already decided by this court, yet the fact also remains that a wrong mentioning of the period of entry can certainly create serious prejudice to a person who is sought to be. But we do not wish to enter into this arena in as much as that issue has been already, we are not called upon to decide that in this review petition, as in our opinion, the said does not fall within the scope of review petition. In as much as we are only concerned as to whether there was error apparent on the face of the record, which we have already held to be so. Under the circumstances, we have the view that the order passed by this court on 3/12/2018 would be liable to be recalled. Full stop. That leaves to the next. That leaves the next course of action. Once we have held it, that the aforesaid order dated 3/12/2018 pass in 5 WPC number 5/888 of 2018 deserves to be reviewed. The matter ought to be heard afresh. However, considering the nature of the case as discussed above,
My
we have
lord,
the
here
view.
I have objection, my lord.
We have the view that it may not be necessary to rehear the matter in as much as the reports are before us and we have already gone through it, and the error apparent on the error which is clearly apparent on record. Under the circumstances, we are also of the view that the opinion rendered by the learned tribunal cannot be sustained in law, and accordingly we allow this review petition by recalling the order dated 3/12/2018 and considering that discussion is considering the materials, and for the reason discussed above, we are also the view that the judgment dated the opinion dated 21/6/2018 passed by the learned foreigners tribunal passed Assam in FT case number 301/2018 also cannot be sustained and would be liable to be reconsidered by the tribunal by taking into consideration that Atorjan Akon is a female and cannot, and as such in absence of any evidence cannot be treated to be the elder brother of Hazrat Ali, which has been held by the learned tribunal. So accordingly, we have the view that the matter would require to be reconsidered by the foreigners tribunal in the light of the evidence that had been brought on record and evidence adduced for refresh reconsideration in the light of the observation made above. Accordingly, the present petition is set aside. Accordingly, the review petition is allowed by setting aside the impugned order date by setting aside the order dated 3/12/2018 passed by this court in WPC 5/888/2018, as well as the opinion of the learned tribunal rendered on 21/6/2018 in FT case number so and so. The matter is remanded for fresh reconsideration in accordance with law in the light of the observation made by us.
My lord, my submission was, my lord, in last part, my lord. When your lordship has recalled the earlier, my lord, order, I may be given sounds to it. My lord, here they argue the
There is nothing to be. What is there to?
No, my lord, there are issues. my
Anyway, we
lord,
have passed the order. You can.
They- My lord, they have not pleaded that fact in this writ petition. So we may be given the chance to argue in the writ petition, my lord.
Because Mr. As regards the submission advanced by Mr. Aang, that the review petitioner has not specifically pleaded in the writ petition about the mistake committed by the error committed by the tribunal by treating the said Atorjan Akon as the elder brother. We have the view that the said submission may not detain us in view of the specific finding arrived at by this court also in WPC number 5/888 of 2018 to the fact that the said Atorjan Akon is the elder brother of the petitioner in the teeth of the original records which are placed before the court, because from the record it is also clear that this court, while passing the order on 3/12/2018 in WPC number 5 5888 of 2018 had called the records, original records, which are also produced before us, before passing the said order.
And my lord, that plea that his mother, neither he has pleaded anywhere, nowhere he has pleaded.
That we have already made observation that he has not pleaded also that, but that does not mean that the tribunal can, that we have already made observation. Yes.
No, my lord, point, my lord, our point was that we may be given the opportunity, it's because I was not in arguing that writ petition, man. I was
The
arguing in the
submission
review.
of the learned counsel, Mr. Payang, that the matter may be listed for fresh hearing, in our opinion, would be of not much practical, not be of much useful purpose in as much as in view of the specific error, in view of the record which is placed before us, which clearly indicates the error apparent on the record. And I said it will be merely time consuming and delay the proceeding. And it is, we have the view that it will be better for the tribunal to reconsider the matter afresh.
Item number 2.
This is the matter for hearing, Spencer.
May I please, your lordship?
You hear it? Yes.
In this case, my lord,
What is that?
as per the order dated 6/5/2021, instruction was sought from the respondent
What about-
whether the person appearing before this honorable court and the person against whom the reference is made is the same person or not.
whether some direction was issued by this court?
Yes, lordship.
What is that? What is your specific case? Considering
I'm
ex parte order?
Asiruddin Mia.
Asiruddin.
Yes. And Mainuddin. I'm son of Ainuddin Mia.
Considering peculiar, we are inclined to call for the original records of FT Dhubri. Has it Dhubri been received? Huh, just see. Whether FT, original FT record Dhubri is not here. Considering peculiar nature of the case, we are inclined to call for the original records of case number from Dhubri. Is there? Dhubri? Huh? Is there? FT 4/22/25? Huh? 4/255 GPR 2016. Foreigners Tribunal 4, Dhubri. Case number is there? Or it has been recorded. Ms. So submits that because of ex parte order passed with the Foreigners Tribunal, wherein one Asiruddin, son of so was proceeded, the authorities considering similarity in the name of the present petition and treating the present petition with separate may be subject to detain in terms of said ex parte order. The present petition Asiruddin, son of Ainuddin, and present residing village so. And I said the present petition is a different person, not a proceeding. Under the circumstances directed, though will have full liberty to proceed in accordance with the Asiruddin, son of Mainuddin, village Alongor, was declared to be, however, the said ex parte will not, shall we not endow also including police foundation. Yes, anything, have you taken any clarification, Mr. Payang? As the order 6/5/2022.
Sorry, my lord, I don't have any instruction.
Okay, then let it come up. Mr. Payang had missed that the Ghosnane Council. Also, Mr. Payang submitted he has no, cannot receive an instruction. Let him open so. This is a matter after a month. In the meantime, early interim order will continue.
My lord, I may be allowed to check the records. I'll just take them.
Okay, thank you.
For hearing, item 3.
What is this? Aminur,
Yes, my lord. So, review petition, my lord.
we will hear some other day. The matter will be listed for hearing again, and so. Hearing will so hearing some other day.
Item number 4.
Is there error apparent on the face of
Yes,
record?
my lord.
What error?
My lord, his name is Aminur Ali. And tribunal by issuing notice, Aminur Hussain, Aminur Islam, everything is disbelieved, my lord.
Oh, we'll see
Documents
that.
are Aminur Ali, my lord.
Okay, we'll set Ali and Hussein, we'll see that.
And the
Yes,
admit
again.
card, TCLC admit card not believed.
Next.
Item number 4.
Numita Ghosh. What is this, Numita Ghosh?
That is the lordship, their argument was already, hearing was already being made. And even this, from the respondent side, lordship,
When? Before whom?
before this honorable bench.
This court.
Yes,
You
lordship.
don't know. Substantial arguments have been advanced,
Yes, lordship.
though certain clarifications required.
Ah.
Where is that? We don't know. We don't remember anything. This case is as fresh as any other case. Doesn't appear
It's,
familiar to us. We don't remember anything. What is the matter about?
It's the petition, mother has adduced evidence.
Mother has evidence.
Yes, lordship.
That, so what is the evidential value of the mother?
Yes, section 50, all those were argued, and even from the respondent side also, it was argued, lordship. And even the rejoinder argument was also being made.
Yes, Mr. Pine.
My lord may take it some other day, my lord.
Okay. When?
Any other day, my lord.
I'm Mr. Ghosh. How soon? This again also answer. Yes, next. Over.
List over.
Difficulty today. Item number 10. 10.
Item number 10, huh?
10, your lordship.
On the prayer, Mr. Swanson. Yes, next. Next.
Yeah, please, Lordship. Lordship, I beg to mention item number 12, Lordship.
On the prayer, we want adjournment. On the prayer of Swanson. Yes, next.
Objection.
Next. Item number 1. Non-appears since the records have been received. Material list for
Item number
hearing.
1.
Yes, you're there. Item number 1, list for hearing.
Yes.
Okay, since the records have been received, the material list for hearing. Yes, item number 2.
Item number 2.
Same order. Okay, same order.
Item number 3.
Elsewhere? Yes, same order.
Lordship, the petitioner before your lordship died.
Died.
Yes, lordship.
So what to do? Tell us. If he has died. If Kudus Alu has died, Kudus Ali has died, then what will you do?
Kudus, lordship.
Then what will you do?
Case can you post, lordship?
Close. If the case is closed, then what is the effect you know? What will be the consequence you know? This Kudus Ali is a bachelor or what?
No, he has family, lordship.
He has family. He has sons, daughters.
Yes, lordship.
Then they will never be Indian citizens.
Lordship, then. I have no idea, lordship, then.
You have no idea. Are you in touch with your clients?
Yes, lordship. Abdul Kudus.
No, you said Abdul Kudus has died. How you are in touch? Huh?
Lordship.
You are in touch with a dead person. Huh? You are getting scared. Eh?
Death certificate, lordship.
Huh? Are you in touch with whom? You are in touch with whom?
Lordship.
You are in touch, you are in communication with whom?
Lordship, instruction is there, lordship.
Who has given you the instruction?
Lordship,
Who has given you the instruction?
my senior instructor made.
Your senior instructor. Who has instructed your senior? Not by Abdul Kudus.
Maybe his family person. I have
So
that.
you in turn tell your senior, who will in turn tell his person who has instructed him that after Abdul Kudus has died, the legal heirs should challenge this opinion. Otherwise, what will happen is that if Abdul Kudus is declared to be a foreigner, and if that remains unchallenged, then the children will also have difficulty. Okay. Our niece,
P. Begum.
counsel for the. It has been submitted at the bar that the Abdul Kudus, the present petitioner, has expired during the pendency of the petition. Under the circumstances, Liberty is granted to the legal heirs of the Abdul Qudus to impeach themselves in this petition so as to challenge the opinion of the tribunal. Okay. List after in the meantime, list after the month, that means January. In the meantime, list in the month of January. So you file an impleadment application. Impleadment application.
Impleadment.
Ah, that's it.
For admission, item number 4.
Anupa, baby, what do you want to tell us?
My lord, interim is there, LCR has come, my lord, maybe fix on hearing, my lord.
Very good. Since the records have been received, the matter will be listed for hearing.
Item number 5.
My lord, similar prayer,
Same. Yes. Next,
Item number 6.
most of it.
Biju Upadhyay.
Hmm.
Yes.
May I please your lordship? Lordship, as per last occasion, lordship was directed to produce the notification by way of affidavit. Whether the Gorkha community's devoter tag was removed or not, lordship. We have received the notification, but affidavit sometime.
Show us the notification. See, Mr.
Yes,
Good.
Lordship.
Why you want to go through all this and them? Border police shall not follow any case under Foreigners Act against members of Gorkha community. So you are a Gorkha.
Yes, lordship.
Upadhyay is a Gorkha.
Yes, lordship.
Directly to foreign tribunal, how in case of rare occasion the body convenience has come from specified terrorist person, so that the matter shall be referred to Home Department to withdraw cases. Why the case have been referred to as your request comply with decision. So Mr. He is a Gorkha.
Yes, Lordship, but
Gorkha.
if he is a devoter, Lordship, then it will something different, Lordship.
The voter, don't allow him to vote. Ask him to go to Nepal, but not a foreigner. What to the voter? The voter is a what? Doubtful voter. What is this item number?
Item number 6.
6. 4, 5. Whether he's a Gorkha voter, then the voters. Is there any, is that, let us see, Sharma. Impugn order, there's a record. Biju Upadhyay. Name of hesitation has been depicted. What is format for making reference? House to house. Published to the name of and where is the date of 1983. Mother tongue is Nepali. Enquiry assessment of spoken Assamese also. What to do? Tell us. You want to declare him a foreigner or not? Tell us. The Nepali. What about never?
If he is not coming from specified territory,
He is not coming from specific
then
territory.
Lordship may pass order.
Because he has come from where? Let us see. A desired by you, verification report, name Biju Upadhyay, PS, SP number, Shanti Pathor, father, mother's name, Kinmaya, date of birth, Nepali, Assamese. Why they migrate into Assam? Nil. Yes, Nil. What is this Nil? Yes. Why migrated after 25/3? From where?
Yeah, then they'll have to place.
From where? Nil country. What to do? Tell us.
Lordship, if she is not, if the petitioner is not marked as D in the voter list, Lordship, but and if she has been, he is declared as a foreigner, and if she belongs to Gurkha community, not coming from a specific territory, it will be covered by the Indian neighbor judgment, your lordship.
So there is not mentioned that she has come from specified territory.
And in that case, your lordship, they will be covered by the Indian neighbor judgment. Only if your lordship in the cases where the petitioner marked as D in the voter list, that matter is still pending in this honorable court, your lordship, then that will fix to the tomorrow, your lordship, before a single judge. Your lordship.
Okay, D voter.
If it has been D voter, your lordship.
No, of
because-
course, they say there is a, no, let us see, I don't, let us see, we'll check out whether it is a D voter or not.
Yes.
We'll see. Whereas electoral roll of the said constitution was published on draft on 15/6/2005, including therein the name of said Sri Biju, and whereas having doubt about the citizenship. Official, they said the doubt, but I don't know how they.
Whether they been marked as D, your lordship, in the electoral roll, if D was inserted in their name, then that matter is yet to be decided by the single bench, your lordship.
There is nothing, no electoral roll also
Yeah,
given.
then it will be decided, it will come under the covers of Indian neighbor judgment.
It is not mentioned that he is doubtful, but
Not
doubtful,
there.
but then
not
not
D,
reference to any D voter.
Yeah,
In
if
fact,
not
that,
voter, your lordship, then it will be covered by Indian neighbor judgment.
okay. Nico, what's your name?
SP Chetri, Lords.
Khetri,
Yes, Lord.
Indian.
Yes, Lords.
I'll miss Khetri.
Yes, Lords.
Are also Mr.
Yeah, Ali.
Ali, also Mr. Sharma. सबका नाम लिखो. In this petition, petitioner has challenged the opinion dated 16/12/2017 passed by the Learned Foreigners Tribunal, second Dhemaji in Silapathor in FDD case number second Dhemaji 430/2016, by which the petitioner has been declared to be a foreigner. Foreigner declared to be a foreigner foreigner post 25/3/1971. It has been submitted by Chetri, Learned Counsel for petitioner, that the case that the petitioner is a person belonging to Gorkha community, and her case is squarely covered by the decision of this court in Indian Navar versus Swencho. Indian Navar versus Union of India, reported 2020-21 GLT 413. Under circumstances, the impugned opinion dated 16/12 may be set aside. While going through the opinion, it has been mentioned that this is a D voter reference made by the Superior Police Border Dhemaji to the foreigner to determine whether the petitioner is a foreigner or not after 25/3/1971 under the Provincial Foreigners Act 1946. However, though the petitioner appeared and filed her documents, but the Learned Tribunal held that the petitioner could not prove the document beyond reasonable doubt, and he has utterly failed to discharge his burden under Section 9 of the Foreigners Act 1946, and accordingly declared him to be a foreigner post 25/3/1971. Full stop. As regards the above submission made by Learned Counsel for the petitioner that the case of the petitioner covered by Indian Naval, Mr. Ali, Learned Counsel for respondent number
Election Commission of India.
Huh?
Election Commission of
has fairly submitted that unless it is a case of a D voter, unless the person is declared to be a D voter, comma, if the person belongs to Nepal Gorkha community, perhaps the tribunal, in view of the decision in Navar, in the Navar case, the proceeding will not lie. Though having heard Learned Counsel for the parties, we have gone to the original record. Though the Learned Tribunal mentions that the reference has been made to the tribunal by the SP Border Dhemaji as a D voter, we have, while going through the record, original record, there is no such finding by the competent authority as the or the ERO that he is a doubtful voter. It merely mentions that his citizenship is doubtful. Though the ERO also mentions that in the electoral roll of the constituency, of constituency published on draft the electoral roll of the constituency of 114 Junai ST Assembly constituency published in draft on 15/6/2005. The name of the petition is included. But no reason has been given as to how his citizenship is doubted. In the verification report submitted by the local verification officer, in the column nothing is mentioned. In the format nothing is mentioned from where he had arrived from. Unless the authorities doubt that the person has entered from the specified territory. And also, as mentioned by Mr. Ali, that there is a observation by the competent authority that his citizenship is doubted. We are afraid, we are also view that the case of the petitioner will be covered by the decision never so. Under the circumstances, we allow this petition by setting aside the impugned so in the light of the decision of the Indra Nevar
Lordship, may if I add the word, if I humbly submit the Lordship, because in this case, the opinion has already been rendered. As such, it will be covered by Indian Nevar, Your Lordship.
Okay.
Had no opinion been rendered as of date and she has been marked as D, then Indian she would not have been covered under Indian Nevar judgment.
Okay. Mr. Ali submits that since the opinion has been already rendered, even if there may be some doubt about his the citizenship, in view of the decision of the Indra Nevar case, the case of such proceeding, who belongs to Gorkha community, proceeding will not lie. According to understanding, we allow this petition by setting aside.
Obliged.
Item number 7.
May it please see my lordships?
Item number 7.
Lordship.
Along with item number 15.
What is there? 22. Ramjan Ali, what happened to you?
My lordship, this is an appeal against judgment on order dated 1/9/2022, my lordship, passed by the learned session Judge Morigao, my lordship.
You have been convicted as?
Life imprisonment under section 302, my lordship.
Okay, so what to do now?
My lordship, in respect of respondent number 2, notice may be issued, my lordship.
Okay, Han Miss.
MSL.
Yeah?
My lordship, I'm so sorry, my lordship. IA is there as item number 14, my lordship.
Yes. So we will issue notice on the IA.
My lordship,
You want bail, na?
my lordship.
Okay, Han Miss.
MSN.
M Hassan. A Hassan, na? M Hassan.
MESEN.
Yeah, MSN, Learned Council for the applicant. Issue notice reasonable 3 weeks.
Obliged, my lordship.
Applicant who takes for service upon response. PP who accept notice, Miss so accept notice on behalf of. You give a copy to PP.
My lordship.
The applicant who takes for service upon response number 2 by resta post with AD.
Obliged, my lordship.
Appeal of course will admit the appeal also. Appeal also has Miss Mason and Council for the appellant. Appeal is admitted, call for the records.
Obliged.
Orders, item number 8.
Nepal Das. Nepal Das, you are Nepali or no? Just borrowed the name Nepal.
I'm Bengali.
You are a Bengali,
Yes, lordship. My lord, here
but you are not from Nepal.
No, I'm not from Nepal. My name is Nepal, but I'm not from Nepal.
So what is to be done today? Tell us, Nepal Das.
My lord, here in this case, my lord, one ground is that there is no reference against other petitioner. Only with Nepal Das, there is a reference, but with regard to the other petitioners, they were declared as a foreigner, there were no reference. So I would like to rely upon
Then what about Nepal Das?
Nepal Das. There is no discussion of DW2 in the critical analysis of the
Who is
order.
DW2?
DW2 is the neighbor lordship. Who knows Nepal Das
How long you have been neighbors?
since his childhood?
Since childhood.
Yes, DW2's childhood.
Childhood means which year?
He was 56 when he adduced evidence.
You know that gitti, you play, no? During that time, there was no cricket or the days
Yes.
to play
Lordship, there's
gitti.
an issue of delay here, so we'd like to address.
How much delay?
Delay, Lordship,
How long you have been sleeping?
not sleeping. I have approached this honorable court and it was without calling the records. This honorable court dismissed the matter. We approached Honorable Supreme Court and thereafter this review petition is being filed.
The
Lordship.
Supreme Court said that you can go file.
Yes, Lordship. And delay also,
How
I
many
would like
days?
to-
Otherwise, how many days, months, years, how many delay?
not even couple of months, Lordship.
Couple of
definitely. Yes, Lordship. Exact date I will.
So Lordship, this issue on delay is supposed to be addressed by me, Lordship, in this matter and couple of other matters.
How many days delay?
2018, I have filed the writ petition and on 1/10/2018, it was dismissed. Then SLP order was of 8/2/2021. And thereafter,
When did you file? When did you file?
I filed on,
SLP was dismissed 21,
yes, Lordship, 8/2/21.
8/2/21.
Yes, Lordship.
And you filed this petition?
I filed it on August 2018. August 2021, Lordship.
So that means that 6 months.
Yes, Lordship.
6 months. 6 months.
November
November
2021.
2000.
November 21.
26th of November. And it was dismissed by the Supreme Court in February.
February, Lordship.
March, April, May, June, July, August, September, October, November. 9 months.
Yes, Lordship.
So 9 months you are doing what?
So it's being communicated and thereafter they had to come and in between that time also COVID was there, Lordship.
COVID was there.
Yes, Lordship.
So Mr. What do you want, Mr.?
So here,
Lordship, as far as delay is concerned, Lordship, this issue has to be decided.
No, we'll decide.
yes,
We have to
Lordship.
decide. We want to decide. as
Yes,
many-
Lordship.
That's why, Lordship, I would like to.
Before I retire, I want to decide.
Yes.
After retire, I can't decide anything. So I will decide.
Yes,
You
I
argue.
will.
What is being
like to
decided,
take
whatever
it.
listed, I will decide. We will decide.
The Lordship,
Yes, Lordship.
I have a small prayer, Lordship,
What is it?
because this matter, like I will place certain case laws in this matter.
Place it.
And certain,
I'm ready with the case laws. I today also brought 2 case laws.
I'm submitting.
On
please allow
Yes,
me to
yes,
submit.
yes, boss.
What I'm, Lordship, I'm submitting is that, Lordship, there's a matter fixed at 2 o'clock in court number 1. If you have, Lordship, can accommodate me for some time, then Lordship, I would like to address this matter, Lordship.
Next week. Next week.
Next week, anytime.
Yes,
Lordship.
Lordship.
Next week করে দিও Monday করে দিও whatever it is. Next week করে দিও. Yes.
Next week, Thursday, Lordship.
Thursday, okay.
Thursday, Lordship.
Yes.
112.
Deeply inside.
Alo Nundi. Who is this
My
Alo
lord,
Nundi?
Both these
My
matters.
lord, this matter is similar to Mrs. Ghosh's matter. So we may have it on Thursday. She'll lead the
Same
day.
matter.
And I'll
Okay,
just
Thursday.
Same, Lordship.
plug the lacuna which left by my friend.
Okay then. Alo and Nepal are on Thursday.
And Nepal happens to be Alo's
Alo.
father in another.
Alo,
No,
Alo,
not this Nepal. It's a very common Bengali name as I've been informed.
Alo is light. Light. What happened to the light? Your light has
Light
been
is gone out,
extinguished,
my lord.
Gone out, huh? Switched off. Okay. Next.
Supplementary 14 for orders.
Supplementary 14. Rajendra Sharma. What has happened to Rajendra Sharma? What is this case?
Regarding seniority.
Huh?
Seniority and other pensionary benefit. Yesterday.
Oh, that direct recruitment. Yes, Mr. You are direct recruitment para B. Yes, Mr. Khotanier.
Yes, madam. Regarding his appointment order, madam.
Oh, Mr. First, let us know the law. We have seen that.
Because madam, his appointment was done by the school managing committee. So he is not in a substantive post, madam. The post that has been sanctioned in the year 1996, madam. From 89 to 96, there was no post.
There
madam.
was no sanction post.
There is no
If there was no sanction post, you can't carry that.
No, there are some the arguments to be taken up.
You tell us, Argu, you Argu, we have been waiting for you all these days. Argu? You Argu?
But your lordship is.
What? 150. Oh, that is. So when shall you argue, both of you? Because today 2 p.m. there is some dead reference. We want to complete it.
Any day, your lordship.
Except next week, except Monday, my lord.
Just agree any day. Next
3rd of December.
Huh?
3rd December.
Saturday.
Oh. Then 5.
5:12.
Public.
Next.
For hearing, item 11.
What is item 11?
For hearing.
Nalina Begum. Nazlina. Foreigner. Yes.
My lord.
Yes, tell us what is the problem. Tell us quickly.
Lord,
What is the problem?
declared as a foreigner, my lord.
So you okay? You are a foreigner. So what to do?
My
Tell
lord,
us.
this is a case arising out of the ERO's report, my lord.
Here report.
My
What
lord,
is
it is not the normal course that the ERO reference has been made. There are some discrepancies in the record.
We will
also.
hear. We will hear you. Some other day we'll hear.
My lord.
Okay,
Next week, any date, my lord.
Not next day. First we are busy with some dead reference. We will see
My
that.
lord, my lord.
Stay matters, item 13.
Obliged.
Tara Banu.
Lord, this is also, my lord, it has come up as an stay matter, my lord.
So you have to stay. You got to stay.
I have got.
They will be listed for hearing. Yes.
My lord.
Yes.
Obliged.
Yes.
List over.
This over. So, Mr. I think we'll sit at 2 p.m. We'll try to finish it up today.
Yes.